Everybody. Also, just want to notify, with the media representatives seeking permission to film or take photographs, I'd just like to advise the representatives of the media that have requested permission to film and take photos of the committee's proceedings, and the committee has agreed, the committee agrees to this. Everyone's in agreement? Yeah. All in agreement? I remind the media that this permission can be revoked at any time, and the media must follow the direction of the Secretariat staff. If a witness objects to being filmed or photographed, the committee will consider this request. The media are reminded that they are not able to take images of senators or witnesses' documents or of the audience. Media activity may not occur during suspensions or after the adjournment of proceedings. Copies of Senate Resolution 3 concerning the broadcasting of committee proceedings are available from the Secretariat. Thank you. I declare open this hearing of the Senate Education and Employment Legislation Committee into the Fair Work Legislation Amendment Secure Jobs Better Pay Bill 2022. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to the elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. These are public proceedings being streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to the committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses have a right to request to be heard in camera. The Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to the superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Commonwealth officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. A copy of the order is available from the Secretariat. For the benefit of Hansard and those listening to proceedings, I remind committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. I now welcome representatives from the Department of Employment and Workplace Relations and the Fair Work Commission. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today?
Thank you, Chair. Anne Sheehan, First Assistant Secretary and Chief Counsel of Workplace Relations Legal Division in Department of Employment and Workplace Relations.
Good morning, Chair. Jodie Anderson. I'm the First Assistant Secretary of the Safety and Industry Policy Division in the Department. Thank you.
Good morning, Chair. Murray Furlong, General Manager of the Fair Work Commission.
Morning, Chair. Ms Joel Leggett, Executive Director of the Tribunal Support Branch of the Fair Work Commission. Good,
thank you. I now invite each of you to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions.
The Department doesn't have an opening statement, Chair.
Mr Furlong?
Chair, I have a short opening statement.
Would you better circulate that also to the committee for their
yes,
perusal? Thank you.
Thank you for inviting the Fair Work Commission to appear before the committee today. I thought it might be helpful for me to begin by outlining the way the Commission operates and its functions. The Commission has two arms: the Tribunal arm, which is a quasi-judicial body headed by the President of the Commission, and the Administrative arm comprises of me as the General Manager and staff of the Commission. The main purpose of the Administrative arm is to assist the President in ensuring the Tribunal performs its functions and exercises its powers. The Tribunal arm presently comprises the Acting President, 2 Vice Presidents, one of whom is the Acting President at the moment, 20 Deputy Presidents, 20 Commissioners and 3 expert panel members appointed on a part-time basis. The functions and powers of the Tribunal arm, what it can and can't do, are prescribed in considerable detail in the Fair Work Act. In broad terms, the functions of the tribunal include making and maintaining modern awards, adjusting modern award minimum wages and national minimum wage each year in the annual wage review, approving enterprise agreements and performing functions in the regulation of bargaining and industrial action, dealing with unfair dismissal claims, general protection claims and workplace disputes, and dealing with workplace bullying and sexual harassment claims. The tribunal is independent of the Minister and the Executive Government, and, like judges, members of the tribunal do not generally appear before parliamentary committees such as this. The Act contains various provisions to ensure that members of the tribunal can make their decisions independently. I won't go into the detail there, but in essence, that is the main point I'd like to make on that. Like a court, the Commission does not publicly comment on or discuss decisions of the tribunal. The decisions of the tribunal and the reasons for those decisions are published and open to public scrutiny, and they must stand on their own merits. If a party believes a tribunal decision is wrong, they can seek to challenge the decision through an appeal to the full bench of the Commission or judicial review in the courts. Now to the administrative arm, which I'm responsible for. As the General Manager, I head up the administrative arm of the Commission. I also have some functions at the moment under the Fair Work Registered Organisations Act in administering the regulation of registered organisations. I'm the accountable authority for the purpose of the Public Governance Performance and Accountability Act. I'm able to provide the committee with information about the expenditure of the Commission, resourcing, statistics on usage of the Commission services and other matters going to the Commission's administrative operations. The Commission's role is to perform its functions under the Fair Work Act in accordance with the Act. The Commission does not enter policy debate about the operation of the Fair Work Act or propose changes to the Act. The Commission confines any comments it does make about the Fair Work Act or proposed changes to the Act to pointing out technical changes that might make administration of the law simpler, or where the Commission foresees practical issues with the Act or proposed changes to it. Accordingly, I can speak to the committee about how the Commission will go about implementing the proposed reforms to the Fair Work Act and the resources or the resourcing that this may require, but I can't comment on the merits of the proposed changes to the Act or speculate about how the tribunal arm of the institution will decide matters if the changes are ultimately enacted. If the Commission speculated about how the tribunal might deal with particular issues under the proposed changes to the Act, this could be seen as prejudging matters that could later come before the tribunal. Also, how the tribunal deals with an issue in the future is likely to depend upon the particular facts of the matter in which the issue arises. The Department will be able to assist in answering any questions you have about the policy rationale for the proposed changes to the Act in the bill and how government anticipates those changes will operate. Thank you, Chair.
Good, thank you, Mr. Furlong. I just want to ask a couple of questions, and I'll head over to Coalition. The committee heard from the Associate Professor Chris Wright of the University of Sydney on the first day of the inquiry. Associate Professor Wright stated that currently it's much easier for an employer to avoid bargaining than it is for a worker or a union to compel an employer to bargain. I don't see that the changing under this legislation. Currently, the system is heavily tilted in the favour of employers. These provisions are going to slightly rebalance. They're not going to tilt it the other way. To what extent do you feel that statement is true of the bill, Ms. Sheehan?
Thank you, Chair. The bill introduces some changes for some of the streams in terms of entry into the streams. So, for example, single enterprise bargaining, there can already be a majority support determination for employees to express, their desire to bargain for a single enterprise agreement. That same majority support determination is now being applied in the single interest stream. So there will be an opportunity in that stream for employees to indicate their desire to bargain through an MSD process. So I think in terms of the balance of employees expressing a desire to bargain, I think that would be the key change that I would highlight to enable employees to express their desire to bargain in the single interest stream, which already appears at the single enterprise level.
It might be helpful if you could just explain the requirements that would need to be satisfied to commence bargaining at the multi-enterprise agreement level.
Yeah, sure. So would you like me to run through there's the single, so in terms of multi-agreements, there's the cooperative workplaces stream, which is currently referred to as the multi-enterprise stream. So that's largely remaining the same under the bill, so that will require employers to consent to bargain under that stream. And then there is the supported bargaining stream and single interest stream. Did you want me to run through the single?
If you run through just the key points of the process, so it's just clear to the committee.
Yeah, sure. So for the single interest stream, there's two ways to enter that stream. The employers can consent to bargain in that stream, or there can be an application by an employee organisation that has the majority support of the employees. They would apply for a single interest authorisation. Currently, there's some simplifications that the bill's providing. Currently, under the Act, people that wish to bargain in that stream have to come to the Minister first for an authorisation before going then to the Fair Work Commission for approval. So it will be simplified and get rid of that step of coming to the Minister first for approval. So the application would go to the Fair Work Commission for a single interest employer authorisation. The Commission would have to consider a range of factors. Firstly, would look at whether there was already a single enterprise agreement in place, so an employer couldn't be brought in against their will into that stream if there was already a single enterprise agreement in place, or if the parties had agreed to bargain for a new agreement. There's also discretion for the Commission to look at the history of effective bargaining between those parties, particularly looking at the last 6-month period and deciding whether it would be appropriate to grant an authorisation. And then in terms of the criteria itself that the Commission has to consider, one, they would look at whether there are clearly identifiable common interests between the parties. So that is a discretion for the Commission, and you would expect the parties to put forward their views on whether there are clearly identifiable common interests between the employers. The bill provides some examples of what might be a common interest, but they're indicia, not an exhaustive list. The parties are given the opportunity to express their views. The Commission would also consider whether it's not contrary to the public interest to grant an authorisation, and then there is an exemption from the single interest authorisation if the employer is less than 15 employees. So I think at a high level, they're the factors that the Commission would consider in considering whether to grant an authorisation to bargain in that single interest stream. Are you interested in supported?
If you very quickly, if you
supported
could
bargaining
run through it.
as well. So this is designed to, I guess, make this this stream more accessible. It hasn't been the current low-paid bargaining stream hasn't been a particularly successful stream to date. So the criteria for entry into that stream is designed to make it, I guess, see more use out of that stream. So the Commission would need to be satisfied that it's appropriate for the employers and employees to bargain together, having regard to a range of factors. They include the prevailing pay and conditions within the relevant industry or sector, including looking at whether low rates of pay prevail in that industry or sector, whether the employers have clearly identifiable common interests, again looking at the commonality between the employers that would be bargaining together, whether the likely number of bargaining representatives is manageable. And then also there's a broad discretion to consider other factors the Commission considers relevant.
Thank you. Just something, again, to the Fair Work Commission. In the department's submission to the committee, it mentions the additional funding that Fair Work Commission will receive by the October 22-23 to reflect the expanded nature of its functions within the bill. Can you just outline the additional funding to the Fair Work Commission and how this funding will be used?
I might start and then hand over to Mr Lambach, Senator. We received funding for 3 measures to increase our full departmental appropriation for this financial year from just over 80,857,000 to 88,405,000. Our total budget then increases from $88 million to $101.671 million in 22-23, which is the first full year of the funding for the new measures. In terms of the specific funding attached to each of the measures, I'll ask Mr Lambach to assist with that.
Thank you.
Jack Lambach, Executive Director of Enabling Services. In the October budget, we received funding over the forward estimates for the transfer of the ROC of $26.517 million, funding of $11.996 million for the Respect at Work measures to implement Recommendation 28, $20.26 million for the expert panels, and $7.934 million to provide bargaining support for small businesses.
Thank you. Over to the Coalition. Thanks.
Thank you, Chair.
Senator Cash.
Thank you very much. I'd just like to continue on a line of questioning in relation to the impact of the legislation on small business in particular. I do note that the Office of Best Practice Regulation has criticised the department for not providing evidence that the regulatory costs and their assumptions have been tested with stakeholders. My questions will be coming from the regulatory impact statement itself. If I could refer you to page 50 of the RIS, which the impact on employers of option 2, improving access to single and multi-employer agreement. This section refers to a number of assumptions that underpin the department's estimate that the cost of multi-employer bargaining changes per business would be as follows on page 53. Per small business, $14,638. Per medium business, $75,148. Per large business, $94,311. Can I ask you, in terms of in particular small businesses and medium businesses, putting aside employer groups, how many actual small and medium businesses did the department speak to in relation to ascertaining these costs? And could I have a list of them as well?
Thank you, Senator. Can I just confirm that you're referring to page 50?
53.
Of the revised explanatory memorandum that's
The
now
RIS, the Regulation Impact Statement, Department of Employment and Workplace Relations.
Thank you, Senator. So, as per previous evidence, in terms of the reforms more broadly, the department has been consulting since July with a range of stakeholders and employer stakeholders, including COSBOA.
No, I didn't ask for employer groups. I asked for actual small businesses and medium businesses themselves, and if I could have a list of who you spoke to.
So we spoke to, as we would with most consultations, we spoke to the peak employer representative being COSBOA.
Okay, that's all I need to know. Thank you. Have you surveyed actual small businesses, putting aside COSBOA, about whether or not they have the capacity to pay $14,638? And I will take you to your assumptions in relation to that, for the privilege of being compelled potentially to negotiate an agreement.
So, Senator, it might be helpful in terms of the costings, in terms of a regulatory impact statement and how they are normally undertaken.
No, we only have limited time, and I'll go through the questions if that's all right, Ms Anderson. I do appreciate what you're saying, but have you surveyed small businesses about the impact of this cost on them? The actual cost?
We haven't undertaken a survey.
That's all I need to know. Thank you. One might therefore call it a small business bargaining tax. Are you therefore going to do a campaign informing small and medium businesses that the government expects them to put aside potentially tens of thousands of dollars to ensure they can comply with the new laws?
So, Senator, a couple of points to that. Firstly, as Mr Furlong outlined, that the government has committed $7.9 million over the forward estimates to extend.
So is
the
that a
Fair
yes
Work
to the question?
Commission's-
You will be undertaking a campaign informing small and medium businesses that the government expects them to put aside potentially tens of thousands of dollars to comply with the new laws. These are the figures from the regulatory impact statement. Small business need to understand that if they are compelled to bargain, they will need no less than $14,638. I'm assuming there'll be an email going out to them telling them they will need this money. Is that correct?
Senator, the question in itself, I can't accept the question of how it's put. I mean, there's a number of factors that need to be considered in terms of the potential impact or cost on a small business.
But this is your cost in the regulatory impact statement. I'm not making the cost up. It sets their bargaining per business plus cost of external consultants per business, and we'll turn to the external consultants shortly. They're your figures. I'm not making them up. It says per small business $14,638, per medium business $75,148. To be fair to small businesses, they do need to know this. If this legislation goes through, they're going to have to put some money aside to be fair to them.
So,
Or is there no cost involved?
Senator Cash, can I?
No, I'm just saying, is there no cost involved?
Senator Cash, I'm loathsome to actually interfere with anyone asking questions, but I think Ms Anderson wants to answer it, and I appreciate if the answer isn't in the direction you're suggesting, then you may do a follow-up question relatively quickly.
Thank you, Chair.
So, Senator, as per my previous, where I was going with the previous response, we have provided $7.9 million over the forward estimates to the Fair Work Commission to support small businesses in the event that they do wish to engage with bargaining. I would note that in relation to the single interest stream, that the employers with less than 15 employees are exempt from that particular stream. In respect to small businesses generally, they are able to bargain under the current framework. So if employees choose to bargain under the current framework, there may be costs associated in terms of time spent negotiating with their workforce, and in terms of the cost, they are an estimate per employer.
So they could be higher, is what you're saying?
They could be a lot lower. For example, when an employer chooses to use the cooperative stream, for example, that's designed to bring a number of employers, particularly say small businesses, together for the very reasons that you're outlining, is that if a number of small businesses come together, that cost would reduce significantly in terms of their ability to bargain.
Thank you. We've only got limited time. You mentioned employees 15 and under. Can I just ask, how many employees, how many small businesses are there between 20 and 199? Because they will be affected potentially.
Senator Cash,
Sorry, maybe
Shane
while my
also had
colleague's
a...
finding that information, I might just draw your attention to the footnote 71 of the RIS, which does indicate that those costs are estimates only. Many employers may be members of employer organisations, which would reduce their cost if the employer organisations assisting in bargaining. Of course, many businesses already involved in bargaining are incurring those costs as a usual course of business as it is right right now. So I think they're relevant factors in looking at costs of participating in bargaining.
Okay,
So if we could then jump to Chair, given our limited time, in terms of the assumptions that have been built into the costs, which you admit could be higher, let's talk about the estimated cost of the consultant. The consultant that the department has, I might say dreamed up, but that would probably be unfair, being $175 per hour. How did the department come up with this figure?
Senator, bear with me for a moment. So in terms of regulatory impact statements, the figures that we're required to use are often drawn from average uses of either consultants or hours per, or what a sort of an average hour might cost. So in terms of those figures, they're usually standard.
Right.
Standard costs.
Okay, so were quotes obtained from specialist bargaining consultants?
Sorry, Senator.
Were quotes obtained from specialist bargaining consultants?
Senator, I'd have to take that on notice.
Okay, so then let's jump to, is it true that the department actually got this figure from the website? And I'm happy to hand out, Chair, or table for the committee the website, www.authentic.com.au/how much should I charge as a consultant?
Senator, I'm personally not aware of that website. I'd have to take that on notice.
It is referred to in your regulatory impact statement. So which member of the department Googled, how much should I charge as a consultant?
Senator, I'd have to take that on notice.
It's in your regulatory impact statement. You don't know whether or not you've actually gone out and asked bargaining consultants what their estimated cost per hour is. Therefore, how can you be sure that the cost to small business is only $14,368? Because we're about to get on to the other assumptions that the department has made, which is that approximately, and I quote, is it 15.2 employers will actually bargain together for an agreement? Is that also set out in the regulatory impact statement? They'll bargain together under the one multi-employer agreement and this is the interesting bit, because I haven't spoken to any small businesses or medium businesses who've said they'll do this, and I think Senator Hanson may have some questions in relation to this as well. They will all pool their money and hire one or two consultants to represent them during negotiations, which I personally find fascinating, given the department couldn't tell us what a common interest was. So let's work on the basis that you have the 15.2 employers bargaining together. Let's work on the basis they've been compelled to bargain together. Let's work on the basis, because they have a common interest, they are actually competitors. I really need to understand, under what scenario did the department dream up that they will all pool their money and hire one or two consultants to represent them during their negotiations? I'm assuming this involves the exchange of confidential information to ensure that I am properly represented. Did the department put this proposition to employers, and if so, who? And what did they say?
Senator, the regulatory impact statement uses methods that we have consistently used with other legislation. For example, the the SAGER bill under the previous government, we used very similar costing and modelling in terms of usage or potential usage for various proposals under that agreement, for example. So the regulatory impact statement process does require of the department to consider various scenarios and to look at, and I suppose, an average outcome of what might, how a particular proposal might be used. So, as Ms Sheen pointed out before, and I think the footnote referred to as well, these are, average estimates. They also, I suppose, in practice as well, as already noted, that many small businesses particularly are members of industry associations, so they may well use their industry associations such as COSBO or other industry associations to represent them as well. So this is an example of how the proposal may play out.
And this is the problem I have, with all due respect, may play out. How many small businesses are members of industry associations?
Senator.
You don't know. That's fine. With all due respect, you don't know. Can I then take you very briefly to page 51 of your regulatory impact statement? The department has estimated that time spent by staff on bargaining per day is 4.6 hours per employer. This would be approximately 23 hours per week on bargaining negotiations. Was this figure raised with small business stakeholders during consultations?
Senator, it wasn't, but I would refer just to my previous response to this is a fairly standard calculation that we've applied, and we have applied it to previous legislation in this
We
space.
haven't. My understanding is the previous government didn't look at multi-employer bargaining, with all due respect. In consulting with small businesses, or not, about what this would mean for them, let's talk about a busy hairdresser. A busy hairdresser that has more than 15 people headcount, so they are in. For example, a hairdresser who owns the salon and works in it day to day, and if they are the person doing the bargaining, I'm assuming that they factor in, I work from, 8 until 6. They then also need to now factor in the 4.6 hours a day to bargain for a period of up to 6 months. In coming to the cost per business of $14,638, given this hairdresser is now down 4.6 hours, or alternatively, they don't sleep, it's one of the two, did you account for opportunity costs that would arise in this situation in coming to the $14,638? Did you assume they potentially might hire an additional person to actually undertake this bargaining?
So, Senator, the costs are usually made on the assumption that a person within a business may be engaged in the bargaining process.
So it could be the owner. It could be the hairdresser in this example, the owner of the salon.
The most experienced often.
Senator,
Yeah.
it could be the owner of the salon.
Yep, okay. Thank you, Chair.
Thanks very much. Senator Lambie.
Sorry, can I just add to that
You
answer
should.
in terms of some of these calculations going to the cooperative bargaining stream, and I think a key feature of that is that employers are choosing to bargain in that stream. So this idea of when employers might pool their resources towards a common purpose, for the cooperative workplaces stream, there's no MSD process for employees to insist on initiate bargaining in that stream. That's at the employer's desire and the employer's agreement. So employers would collectively be deciding that's in their interests and what they are wishing to do.
Thank you, Ms. Sheen. Senator Lambie.
Thank you, Chair. I just want to briefly talk about the structure of the Fair Work Commission. How many commissioners are there now? Have there been commissioners? Has there been new commissioners already put in since the new government? And how many more commissioners will there be when the bill is passed? So I guess we can say how many commissioners were on it before 1st of July this year? has there been any new commissioners put on between now and then? And what is the intended uptake of the commissioners once this bill passes?
Okay. I might start with the current composition of the tribunal. There's currently a president, an acting president, 2 vice presidents. One of those vice presidents is the acting president. The president of the Fair Work Commission notified, he resigned his commission last week. And there are 20 deputy presidents, and there are 20 commissioners, and then there are 3 part-time expert panel members that assist with the annual wage review at the moment. In terms of the composition at 1 July, I might have to take that on notice because obviously members retire at certain points, and I just need to make sure I get that right for you. But it wouldn't have changed much in essence.
Okay, is there expected to be a change once the bill goes through? What does that look
yes,
like?
Yes, the measures, the funding provides for 8 new members, and they distributed through the 3 measures, 1 deputy president and 7 commissioners.
Okay, and can you tell me whether, you can take this on notice if you like, but do any of the commissioners have a union background, or have any of them belonged to a union or hold union membership, or have held a union membership? So you can take that on notice if you like. I just want to quickly...
Just to be, sorry, while we've received funding for them, the members haven't been appointed, they haven't commenced with the commission yet. So in essence, and that is a matter for government in terms of who will be appointed to those positions. But I know you're incredibly busy, but Section 627 of the Fair Work Act outlines the skills and experience of those people who are appointed to the commission, and it looks at things like workplace relations, law, business, and skills or experience in industry.
I'm sure it does, but I still would like to know if they've had a union background, a union, or hold a union membership.
Okay.
So I can get... Thank you. I just want to go into the impact this will have on small businesses, or what they're asking me. The government claims the bill is about getting wages moving, but can't we already do that by using the model award system?
The modern awards system, the modern awards provide the minimum entitlements for employees that aren't covered by another industrial instrument, like an enterprise agreement. So there was a minimum wage increase, as you'd be aware, took effect on the first pay period on or after 1 July this year. And essentially that raised, depending on how much you're getting paid, the minimum rates paid by either 4.6 or 5.2%. So yes is the answer to your question. There is provision for people to receive wage increases via the modern award system.
Okay, so if we use the aged care sector, just got a 15% pay rise, isn't this an example which demonstrates that we already have mechanisms in place to get wages moving in low-paid industries?
That the application was brought about by, from memory, and I might hand to Ms. Leggett here for the detail, by 2 or 3 unions as a work value application.
So couldn't the government just amend the Fair Work Act to make it easier for the Commission to increase wages in awards, if that's what's required?
I might pass that to it's a matter of policy, so I might pass that down to the department.
I was just going to say, I think there's, under the Act, there's probably a range of mechanisms where employees can seek wage increases. So one would be seeking an application to vary a modern award for work value reasons. If they felt the work value hadn't been properly recognised in the past, there's obviously particular criteria to look at. Depending on the circumstances, there might be a case for an equal remuneration order if and there are reforms in the bill about how the Commission goes about considering, equality in terms of equal pay. So there are, and then also bargaining reforms are, designed to, to boost wages through increased bargaining as well. But I'd say there are, under the Act, and my colleague might be able to say more about the awards mechanism, but there are, I guess, a range of avenues under the Act, some of which are being reformed in the bill as to how.
I think, Senator, the evidence that we provided to the inquiry last time we appeared to was noting that enterprise bargaining agreements do provide for quite significant wage outcomes compared to modern awards. So obviously it does vary across industries, and I can get Ms. Weddington to go through those if you'd like a more of an industry type breakdown. But on average, it's a 70%. Employees are often 70% better off under an enterprise agreement than under their modern award. I know Ms. Furlong captures that sort of data as well on a regular basis and might be able to take you through, for example, what the current annual wage outcomes are.
No, that's okay, because what I'm trying to get to here, wouldn't we better off to fix the award system maybe a little bit more, because wouldn't that allow wage growth to occur in a more controlled environment with no corresponding risk of, for example, supply chain disruptions? Are we not working on that area of the bill well enough? Should we be working on that area of the bill to make sure it's a bit more functional than what it is right now?
So, Senator, the really important thing to note in relation to enterprise bargaining is that it is able to provide outcomes that are more flexible, for example, than, say, under modern awards. For example, employers and employers may wish to look at their rostering arrangements and maybe vary those compared to what's provided for under the awards. So the awards do provide very sort of set structures. They do take they are more difficult to amend, where enterprise agreements do allow for that productivity conversation to happen between employees and employers, and to have more tailored outcomes for their business. It's also a really important cultural piece as well in terms of workplaces. It's really important to be able to have employers and their workforce engaging in terms of their terms and conditions. If you just kept the system to looking at just awards only, really there would be there'd be a missing piece, I suppose, in terms of that workplace consultation and cooperation that you get through enterprise bargaining.
Okay.
Can I just add to that? It's Jennifer Wedinger here, Assistant Secretary of the Economics and International Labour Branch. I think it's important to note that awards are a statutory minimum, and both awards and bargaining, as Ms Anderson has said, are really important in terms of getting wages moving. But what the ABS data shows us is that enterprise bargaining contributes to almost half of all aggregate wages growth, and that's ahead of awards and individual agreements at 11% and 41% respectively. So I think awards bargaining is seen as an excellent contributor.
No, I understand that.
growth.
I'm worried about the disruption to the supply chains. That's what I'm asking you. Do you have that data that says 50% here? Is there more? Does that mean there's more when it comes to supply chains? There's more disruption in that. Has it been broken down that far? What does it look like with award wages? Is there disruptions in the workplace because of that?
So, can I just confirm, in terms of your concerns around disruption to supply chains, can you be a bit more specific? What is your concern around industrial action occurring, or can we just clarify what the concern is?
Yeah. So obviously, if you're in an industrial action, and you're having and then you have supply chains under you, that disrupts the supply chains as well. It has a flow-on effect right down from here to the bottom if you're not getting it resolved. You've only got to look at what's going on with the industrial action over the wharfs and the tugboats at the moment. God help us over the Christmas time if that continues, that sort of thing. So what I'm asking you, is anybody gone into the award system? Is there a better way of doing the award system than what we're doing it now to increase wage growth?
So, Senator, it might be just worth, though, if we outline some of the provisions in the Act that actually go to those concerns around supply chain disruption, because the provisions do provide probably stronger safeguards in terms of some of those concerns around industrial action. I might just...
I think I've heard you speak about this when we were at the last time, but Sure. Can you supply that to the committee? I don't think, yeah. We just
I mean,
seem to be
I'll
moving.
probably
I'm just
say
worried
really
about these
quick-
awards, okay? They've got government written all over them. I just wonder if we could do a better job in that system itself in the awards, especially for the lower employed people down the bottom, whether it's the childcare workers, whether it's the aged care workers, because government has a place to play here in this. Right, and if they don't believe they're getting paid enough, that takes me back to the award system. All right? So that is my problem here.
No, I think in terms of what Michelle outlined earlier, in terms of, say, the supported bargaining stream, unfortunately to date that stream hasn't delivered those wage outcomes for some of those sectors that you talk about. What the government is doing
Why?
with these, well, what the government's doing with this bill is increasing access or improving access to that stream, so that those people that you talk about can bargain more effectively.
Okay.
Senator Lambie, Ms. Sheen was just going to say just briefly, I think she's taken on notice, but if it's very brief.
Yeah, I mean,
Senator
just being
Lambie's.
very brief about the industrial action point in terms of, I assume you're meaning within a multi-employer bargaining scenario, then voting for industrial action would have to occur on an employer-by-employer basis, so it wouldn't be one vote across the whole multi-employer agreement. If you're concerned about there being a multi-employer agreement in place, then everyone taking industrial action, it would be a vote employer by employer. And then also there's the bill introduces a requirement to conduct conciliation before taking industrial action.
I understand that. I'm
So-
just trying to get to wage growth.
Yeah,
Yeah,
I mean,
we
I
don't
would
seem to be
say-
getting the answer of exactly how the wage growth is going to happen,
And I think
especially for those lower
awards
paid
and
workers.
bargaining, I guess, both important elements, as are other aspects of the Act, like bringing work value cases and your equal remuneration. There are, I guess, a range of factors that can, or a range
Okay.
of avenues that can assist.
Okay, so I want to go into the common interest test. Is it true that the bill in effect means competitors may be forced to bargain together?
So no, I think
Are
that-
competitors, can it mean that competitors may be forced to bargain together?
So we've provided some information in detail in our questions on notice from the last hearing around the range of factors that the Fair Work Commission has to consider to grant an authorisation to bargain.
Yeah, I know,
within a
we've
single
seen that.
interest
We're still
stream.
concerned
So-
about it. That's why we're asking you the question.
So I think I would direct my response to those answers that we've provided, that there are a range of factors that the Commission has to consider in granting an authorisation. There's an interaction as to whether there's an employer already has a single enterprise agreement in place. The Commission does have
But there
to
is a
consider-
possibility they'll be forced to bargain together.
So the
That's what I'm
Commission-
asking you. There is a possibility they will be forced.
And I'm
Whether they
trying to
wanna sit
explain the
there or not.
criteria that's in the
Simple. Will they
the
be
bill.
forced to bargain?
So the Commission would consider, and the Commission has discretion to, has to be satisfied that there are clearly identifiable common interests. The bill provides a non-exhaustive list of indicia that might be relevant to determining that common interest, which we ran through at the last hearings and detailed in our answer to our question on notice, so I won't repeat that for the purpose of brevity. The parties would put forward their views and the Commission has to take those into account. So in the case
okay.
of competitors that didn't feel it was appropriate to bargain together,
Okay.
then they would put their views to the Commission and the Commission would take
So
that into
they may be
account
forced
in
to bargain.
determining
That's what I'm
whether
asking.
it was not contrary to the
Okay.
public
May I-
interest.
I'm sorry. Ms Sarah Godden,
Yep.
Assistant Secretary, Senior Executive Lawyer, Bargaining and Coverage Branch. It may be useful to add, Senator Lambie, that there is a long-standing exemption from the Competition and Consumer Act for collective bargaining. That exemption has been in place since at least 1965, recognising that there are good social policy grounds why employees may bargain together that outweigh the competition concerns in that respect. So there is an exemption from the majority of Part 4 of the Competition and Consumer Act, which is very long-standing.
How many exemptions have been given in the past?
It's a standing exemption, so essentially the enterprise agreement system is exempt from so it's not, you don't apply for an exemption on a case-by-case basis. It is exempted from those.
It's in
those
section
provisions.
51, subsection 2 of the Competition and Consumer Act
Okay, but once
2010.
again, competitors will maybe still forced to bargain together. Is that correct, yes or no?
Senator, I might also just adding to Ms Godden's evidence there as well. So in 2015, the Productivity Commission undertook a review of the workplace relations framework, and they looked at a specific issue, and it's probably just worth pointing out what the PC found in relation to concerns around competition.
Okay, so while you're at that, did the PC find that that by having competitor employees at the same table will lead to productivity improvements? Did it actually come out with that?
So the PC, I will note what the PC found. So they found that there is strong policy rationale that the regulation of labour markets should continue to be separated from the regulation of other markets for goods and services. Competition policy and the workplace relations system have obviously both complementary and competing objectives that must be balanced. The social policy grounds for retaining a separate WR regime.
Ms Anderson, I'm simply asking you a question. We don't have a lot of time here. It's great to run down the clock. We can ask for another hour and maybe we'll get it. I don't know. But I can tell you, all I'm asking is, does the Commission think having competitor employees at the same table will lead to productivity improvements? Is there a model that says that, have they come out and said anything about that in their last report?
So the PC did note collective action, which is generally limited by competition policy, is a core principle of the workplace relations system.
What about the productivity? I just asked, will it lead to productivity improvements?
So enterprise bargaining has been a linchpin to productivity gains.
No, I'm asking, will it lead to productivity improvements? I think that's what we all need to know here.
The intention of enterprise bargaining is that it does lead to productivity improvements.
Okay, I just want to know also, under the common interest test, doesn't this mean businesses will have to share information about their business to competitors when it doesn't even want to be part of the negotiations? So whether you want to be part of those negotiations or not, if you are asked for information, you will have to share that.
So, Senator, as Ms Sheen pointed out, in terms of the test, the parties have a clear ability to inform the Commission of their concerns in relation to bargaining together, and the Commission must take into account those views of the parties. If there are clear concerns from those parties are able to express those concerns to the Commission.
So how do you intend to protect small employer when the unions are demanding to see their information, or even when another employer wants to see their confidential information?
So small employers are exempt from the single interest stream.
That's the 15 and under.
That's correct. I think the important thing...
So if you've got 17 employees, they are not. Your information is not safe, and pretty much that can be accessed. That's what I'm asking you.
So the Commission will take into account the concerns of the parties as to whether it's in the public interest for those parties to bargain together or not.
So we're all relying on the Commission with our confidential information. That's what you're telling me, yep.
If you like, by all means ask a follow-up question, but I'll go to...
Sorry, Senator, if I may add, the conduct of bargaining negotiations is largely governed by the good faith bargaining obligations, and we would not expect that employers would be forced to share a bargaining representative. For example, if they chose, they could have their own bargaining representatives, even in multi-employer bargaining. So that would limit the degree to which they were forced to share information, and it seems improbable that they would need to share information with each other that would go beyond if they were single enterprise bargaining, given that the scope of those obligations is governed by that concept of good faith bargaining.
And Senator, probably just the other point to note too, under the existing framework we do have the low paid bargaining stream, where there is currently a process where employers can be brought together through that authorisation process. So that sort of concept that you're talking about does exist under the current framework in respect to the low paid bargaining stream.
And also, if I can just add really briefly, in terms of the current streams that we have, the multi...
I just wouldn't want more.
Sorry, just in terms of the current streams that we had, I was going to add really briefly the multi-employer stream that's already in the Act, which will be renamed the Cooperative Workplaces stream. That allows now different employers to agree to bargain together. So I think what the bill does is, in the single interest stream, is introduce that idea that employees can initiate through a majority support determination their desire to bargain. So the employers can already choose to bargain with whoever they want. So in terms of the competition principle at play, that's not really different. It's more just who has the influence to initiate bargaining that's different.
Okay. So I just have one follow-up question. So when it comes to the common interest test and the confidential information, I just want you to explain me how you think this is going to play out with big businesses, like when they're all lawyered up on the same table, fierce competitors, as if they will or should be asked to share information about their businesses. How is that going to help efficient bargaining when you're asking them for information like that? Fierce competitors, big lawyers at the tables. Explain to me how efficient bargaining is going to come out of that.
Senator, we can only, I suppose, again, go through the process in order for single enterprise bargaining to occur in the first place. And if we think about, big businesses potentially, and if they're not in a position that they don't wish to consent to bargain through a single interest process, really important factor is that they need their workforce, at least 50% of their workforce, to actually say, we would like to bargain. So there's that first step. So this sort of concept of somebody just being dragged in because a union says, we want to be part of this is just not how the Act spells out the process. So it's really important to remember that employees in that business, at least, the majority of them in the first place have to express an interest to even bargain. They may well in a big business already have a single enterprise agreement, and therefore they would be continuing to bargain under that single enterprise agreement. So there's a range of factors, I think, that it's just important to remember. It's not a case of just a business being somehow
No. I realise that,
bargain.
but the common interest has been watered down. Okay, so there's more information, as I understand it. This is my problem, is that you can get more information. How much more information do you practically need? How much information on businesses do you need? How much information on whether it's, especially when they're competing with each other, whether they agree to go into a bargaining system together or not? You can only give them so much when you're in competition with each other, so much information. I mean, we've always known that. You're always going to have one up on your competitor. So how is this going to help bargaining at the table?
I think, Senator, it's important to realise that the information required for bargaining is just going to be related to wages and conditions for employees. Businesses compete on many, many different grounds, and the scope of the competition exemption is limited to wage and condition setting largely for employees. In saying that the common interest test is watered down, I think that's a reference to the current factors in section 247, which the minister must consider in making a declaration for non-franchisee employees. At the moment, there are sort of general factors, including whether it would be more appropriate for the relevant employers to make separate enterprise agreements and the extent to which the relative employers operate collaboratively rather than competitively. In opening up the stream, the test for common interest gives broader discretion to the Commission to determine when it is appropriate for employers to bargain together. It doesn't automatically mean that big competitors would be required to bargain together. The Commission would be having regard to a number of factors, including the nature of the enterprises and the terms and conditions of employment in those enterprises, as well as other factors such as geography and whether they're governed by a common regulatory regime. Simply the fact that the two businesses are competitors is not enough for them to be forced into a single interest authorisation.
Senator Barbara Pocock.
Thank you, Chair, and thanks for taking our questions. A few areas I'd like to ask questions around. First of all, on the aged care pay increase that is about to flow shortly to aged care workers, when was that claim first lodged? What's been the passage of time for consideration of that important case?
Thanks, Senator. I was going to say, did you want to, the Commission want to start off? I was got another colleague at the table to assist.
I'll ask Ms Leggett to assist you with that question, Senator.
Sure, thanks, Senator. The case essentially commenced with an application from the HSU on the 12th of November 2020, which started with an application to increase wages for all employees in the aged care award by 25% on work value grounds. On the 17th of May 2021, the ANMF made an application to vary the aged care award and the nurses award, and this application sought to create a separate table of rates in the aged care award for personal care workers and a separate table for the nurses award for aged care workers.
I probably don't need all the steps,
Sure.
but you're giving me a picture of a 2-year period, essentially,
Sure.
a lot of backwards and forwards in the processes of the Commission. Could you give me some insight about what, if this bill were passed and an application were made, say, in relation to childcare workers, what would be different in terms of the passage of time for such an increase and the process? And feel free to be brief, our time is short.
I think as this goes to the bill, I'll pass to the department on that.
Stephen Steele, Assistant Secretary, Employment Standards Branch. Senator, in respect of the amount of time it would take to consider, it's very difficult to answer that because it will very much depend on the circumstances of the case and the evidence that was led. So I don't think it's possible to give a categorical answer. I think what we could say, though, is that the amendments made to the provisions of the Act will make certain aspects of the argument simpler to run. In relation to work value applications, the explicit provision that gender-based factors are relevant and that historical undervaluation should be assessed, in a sense simplifies the argument that's required to bring those matters before the Commission. In respect of equal remuneration orders, if that sector were to bring a equal remuneration claim, the removal of the requirement for a male comparator greatly simplifies the evidence that would need to be led in order to establish the gender-based undervaluation. So, again, I think it's very difficult to say, but it would, in some respects, simplify the kind of argument that would need to be put forward.
Thank you for that. I wanted to then ask a question around limited term contracts and why that is a focus, and not a technical question, but, you know, why is that an important element of to address in this bill? What is the proportion of the workforce, for example, that's covered by limited term contracts that leads to the amendments proposed?
Colleague can probably look up the statistics. Well, maybe I just start at the higher level in terms of the government's objective. Really, here goes to job security, and so rather people just being on on rolling, contract after contract, year on out. Then obviously recognising there's some legitimate purposes for fixed term contracts, which we've reflected in the exceptions, but that's the general policy goal behind that, and my colleague might be able to assist with some statistics.
Yep, certainly, Senator. Just 1 second. You've got your... So, yeah, thanks, Senator. So we have about 3.8% of all employees that are on fixed-term contracts. And going to your point as to why it's an important focus of the legislation, what we're seeing is that around 30% of fixed-term contractors have been with their employer for more than 2 years. And, what we know is that with this form of work, it's most prevalent in the education and training sector, which are female-dominated sectors. And also, I think the fact that, around about a third of them have been with their employer for more than 2 years potentially indicates that the use of this form of work is not potentially what it was intended to be originally.
Thank you. Thanks for that. I wanted then to ask some questions about the Better Off Overall test and the boot. I'm concerned about making sure that no one falls through the bottom of this system. It's very important, I think, and especially in some of the sectors where it really is important, retail, hospitality, a lot of young people, a lot of people without a lot of power. I wanted to ask specifically that if employers change their operation or work arrangements in the course of an agreement, what protection is there that they won't have lost conditions relative to the award provision?
So the bill includes a reconsideration process. So if there had been a pattern of work or a type of employment that wasn't considered at the original time that the agreement went through the assessment against the boot, then there would be the ability to bring an application. Either the employer, employee or employee organisation can do that to seek a reconsideration and say, well, there's this new pattern of work or this, that wasn't contemplated at the time that the agreement went through approval, and seek a reconsideration and applying the boot against that new pattern of work.
So say you're in a hospitality workplace that's never used casuals on a Sunday, and you make an agreement which excludes additional penalty payments because it's not a practice in that workplace. But then the employer changes and does operate on a Sunday. What process? Many of these workplaces are not unionised. They won't be a registered organisation or a trade union there. What process would need to be followed by a worker who is now working on a Sunday without penalty rates and in an inferior position relative to an agreement, a new agreement?
So they could, the employee, so if the employee organisation can also do it, but an employee could make an application to the Fair Work Commission for that reconsideration test, and say there's now this new pattern of work that wasn't contemplated at the time, that the Commission didn't have regard to, that they now should. So
that's a big ask of, often this will be a very young person to undertake. I'm concerned about the burden on a young person to take such a case. Would you agree that is a big burden?
The reason why we put the reconsideration process in essentially is to balance that we've removed from the boot test the need to consider prospective employees, as that was, I guess, during our consultations, hearing that there's complexity and uncertainty that was creating with the need to look at what possible future employees might do. So I'd say it's designed to achieve that balance and actually to provide probably a greater safeguard to actually have those new patterns of work considered by the Commission in the future.
I might also add, Senator, that it provides a pathway for that issue to be rectified without terminating the entire agreement. So at the moment, the limitation of that is that if the agreement hadn't passed the boot, the remedy would really be an appeal against that approval decision, which would mean that the enterprise agreement wouldn't be approved and the whole thing would fall over. So this pathway gives an opportunity for the agreement to be rectified in that limited way in which it hasn't passed the Better Off Overall test without taking the rest of the agreement down, which may provide for better terms and conditions you would expect for all other patterns of work. So it is a more tailored remedy. I am unable to recall the case, but I think there was a precedent to a young employee bringing a challenge, and essentially that has resulted in the entire enterprise agreement not being approved. So the idea of this is that that aspect of the agreement could be rectified, including at a later date, without the entire enterprise agreement coming unstuck, if you will.
I think the case that you cite is a very unusual one in the industrial relations system, where our long tradition has been of collective organisation to enable redressing the power imbalance in the workplace. And I have a concern for the individuals who don't have a union behind them for many, many reasons. There are many reasons why young people aren't in trade unions. A lot to do with occupation, industry, structure of their workplace. So yeah, that remains a concern for me. And I'm also interested, I've been hearing a lot of evidence in another place from women in workplaces around rostering and security of working time and predictability of rosters and so on. What protection is there in making a global assessment? That's something that's incredibly significant to workers in terms of working time organisation and rostering, that won't be traded off against a pay consideration. How are those, for so many workers, those concerns going to be protected around working time alongside pay trade-offs? Are we confident that there aren't going to be trade-offs that will really significantly disadvantage especially women?
Certainly under the existing Better Off Overall test, and this hasn't been amended, this aspect of it is possible that employers and employees trade off both monetary and non-monetary considerations. It's an important aspect of giving the flexibility to employers and employees to come up with a more tailored system of wages and conditions that will deliver productivity benefits to the employees and improve terms and conditions against the award for the employers, and productivity for the employers and improve terms and conditions for the employees. That said, there are no specific protections. It's unlikely that the Fair Work Commission would consider that significant non-monetary benefits would be able to be traded off for monetary benefits. However, that flexibility is one of the parts of the system, or one of the features of the system that we understand is important to drive productivity benefits. There are certain flaws and protections. For example, under the Act, wages must be paid in money. Those kind of base level protections remain, but we haven't amended the ability of monetary and non-monetary conditions to be flexibly negotiated between employers and employees and their representatives in order to ensure that the system can still deliver those productivity benefits that we expect.
Thank you. Thanks for your answers, and thank you, Chair.
Good, thank you. Senator David Pocock.
Thanks, Chair. Thanks again for your time here and for the work you're doing. I just wanted to follow up on Senator Sheldon and Senator Lambie's questions about funding, if I could. As we discussed during estimates, this bill is going to mean a likely increased workload and functions of the Commission. And you noted additional funding. Once the 8 new commissioners are fully funded, how much is left over?
It's a challenging question to answer in the sense, Senator, because it's the members and then their support or associate support around them, and there are all these on-costs associated with travel and property and other things, access to hearing rooms that members need. We worked with the department over several months on the costings. And the consultation between officers and myself and the department over that period to identify what resources we would need to give effect to these reforms. Okay. It's as you know, we're still talking the abstract, so it is in essence relying on as much evidence or information and the history of how these sort of jurisdictions, these case management practices, we have to implement them. Use that as the body of evidence to sort of articulate what you may need.
So does the additional funding, does that include this new body of work that you'll have to do, or is it separate?
It's been the funding measures that that we specifically received funding for, or the reforms. It's expanding the cooperative workplace program to assist small business to make enterprise agreements. There's the dealing with disputes about sexual harassment, so it's in response to recommendation 28, the respective work report. And then there are the expert panels associated with gender pay equity. And there was a machine of government sort of proposed about transferring as you're aware, the functions, the responsibilities of the Registered Organisations Commission to return them back to the Commission, the Fair Work Commission.
So from what you're saying is that these resources are adequate and you won't need any more funding in the next budget?
It's probably a little bit too early to say that, in all honesty. We've worked closely with the department and talked about making the Barrow overall test easier to apply. There may be some efficiencies gained on that perspective, but then with protection action ballot orders, there's now a conciliation conference that's required. So those elements of depending on the final the final reforms as secures passage through Parliament will have a. So I'm just sort of trying to qualify the answer.
Yeah, sure. Okay.
But what I can guarantee you is that if I find that the Commission isn't adequately funded to discharge these responsibilities, I'll be making that very, very clearly known.
Thank you. And if I can just come to the department, and I'd like to refer to a letter between the Office of Best Practice Regulation and the department dated 23rd of October 2022, in which the OBPR provides its assessment of the government's regulatory impact statement on the bargaining changes, and they describe it as adequate and therefore sufficient to inform a decision. However, the letter states, to have been assessed as good practice under the guide, the RIS would have benefited from further analysis of the potential impacts on productivity, real wages and other distributional impact, in particular on gender, statements or evidence that the regulatory costs and their assumptions had been tested with stakeholders, or otherwise an acknowledgement why this had not been undertaken. In light of the OBPR's view that good practice would have been for the department to have taken that additional analysis, why didn't that happen?
Senator, so in terms of the comments there from OBPR, I suppose in terms of the point in time when that RIS was done as well, it was, I suppose, at a point in time during the consultation process as well. So it hasn't taken into account, for example, all of the consultation processes that we've undertaken. Ms. Weeding might be able to add to this, but in the workplace relations space, it's notoriously, I suppose, difficult, to quantify exactly the outcomes of reforms, in the sense that it will be up to individual workplaces to determine how they will utilise the legislation. So there may be workplaces that do take up usage of the reforms in the bill. There may be workplaces that don't. It will be that sort of, I suppose, extent that the reforms are utilised are very much based on the uptake of players within the framework. So it does. It has been a long-standing difficulty, I would suggest, in terms of putting exact sort of modelling and quantifying some of those points, which is a point that we made with OBPR at the time.
Okay. I mean, I find this interesting, given how huge this legislation is and how consequential it is. Reading through, they've got the sort of tiered approach: insufficient, adequate, good practice, exemplary practice, and they say adequate means the RIS is sufficient for a decision but contains a number of shortcomings in its analysis and or the policy development process used to underpin the analysis, such as not conducting a reasonable level of consultation. Are you aiming for adequate? Are you happy with adequate, or how do you sort of take this analysis of the work that's been undertaken by the department?
Senator, might add to this, Weeding.
I can certainly add to what Ms Anderson has said about the difficulty in modelling and predicting the outcomes based on the fact that it is dependent on the approach that's taken by independent parties, such as the Fair Work Commission, and certain independent parties such as unions and employers bringing forward certainly equal pay cases or cases to the Commission. But what I would say is that we certainly did do rigorous analysis to support the bill. And that's based on some of the things that we've said already in terms of what we know about how much bargaining contributes to a premium in terms of your pay.
And sorry, just I understand there's been rigorous, but my understanding is that's why we have the Office of Best Practice Regulations, because one person's rigorous may pale compared to someone else's. So there's this way to actually assess it. So are you saying that it's not fit for purpose, and that the consultation that you've undertaken are somehow not captured in their analysis?
I think it's a difficult one to predict in terms of what the outcome would be, and anything would be just that, a prediction. So I'm not certainly not commenting on the way that the Office of Best Practice conducts, their assessment. But in terms of the complexity of workplace relations legislation and the many approaches that are taken by independent parties, it is a really difficult one to predict into the future. But what we did use was certainly international evidence and economic best practice in terms of the way that we constructed the legislation and informed.
Okay, thank you. On the international comparisons, this is something that we've heard from the department and also during the committee process. And if I can just read out an extract from the Independent Parliamentary Library's Bills Digest, and would love a response from the department. The OECD's analysis does find favourable evidence concerning wage premiums and collective bargaining coverage, particularly for those engaged in bargaining at the firm level. But overall performance tended to be more strongly associated with how well coordinated a collective bargaining system is. The evidence concerning macroeconomic linkages with collective bargaining was weak and faced numerous methodological constraints. Bargaining systems differ considerably across the OECD countries, even among those sharing similar characteristics. This limits the practicability of international comparisons for policymakers.
Yeah, thank you, Senator. I'm not aware of the specific OECD reference that you're talking about, but in terms of the analysis that was taken by the department, we did consult OECD research as well as ILO and other research. What we did find is that a lot of the assessments internationally are either of those just with single enterprise bargaining and those with like a 100% multi-employer. So what we're proposing as part of this legislation is a hybrid. So the reference, as you're saying, I think probably to be colloquial, is about comparing apples with apples. It is difficult. But what we do know is that, yes, we certainly do see productivity gains and excellent wage premiums in terms of firm level, but also part of the objects of the Act is also in terms of gender equality. And what the international research shows is that multi-employer bargaining in particular has a positive impact on gender equality. And we also know that those the low-paid bargaining stream, which Ms Anderson might be able to expand on, is focusing on those industries where there is a high concentration of female-dominated employees, and the international evidence does confirm that multi-employer bargaining can be very effective for that cohort.
Senator, just to add.
Sorry, it seems to me like, the Parliamentary Library is taking a more sort of meta-study approach where you're looking, and they're saying that on the whole, it's very hard to argue those linkages. For example, we heard during the committee process about Denmark, which is held up for its collective bargaining system, but their gender pay gap is only slightly better than ours. So, I guess it's a concern that this is being held up as this is why we should do it, but then the library, who crossbenchers rely on heavily because of their expertise, we don't have the same access to resources as the major parties. They're saying proceed with caution, despite what you're being told. This is not necessarily what it stacks up to be. But anyway, it's more a reflection than a question. Just in the interest of time, I'm really keen to ask about the common interest test, and I've had conflicting views put to me on this, so I'm keen for the department to clarify. Can you confirm that the common interest test is a new test, as opposed to the public interest test, which has some precedent with the Commission?
There are aspects of the Act as it stands now that refer to common interests between employers, but the way that we framed it in the bill is different. So in the bill for I assume you're interested in the single interest stream, there is also a common interest test in the supported bargaining stream as well. Requires the Commission to be satisfied that there's clearly identifiable common interests between the employers, and then gives a non-exhaustive list of indicia that might go to common interest. I can probably pull out, or my colleague might have it in front of her, how commonality is referred to in the Act at present.
Yes, so in formulating the common interest test, we drew on concepts from both the current single interest declaration process for non-franchisees and the current low-paid bargaining stream. Under the low-paid bargaining stream at the moment, the Fair Work Commission must take into account, when determining whether to make an authorisation, historical and current matters relating to collective bargaining, including the degree of commonality in the nature of the enterprises to which the agreement relates and the terms and conditions of employment in those enterprises. So there are also concepts in the in section 247 that go to the degree of commonality of the nature of the enterprises, whether they have a common regulatory regime, the extent to which those employers operate collaboratively rather than competitively, for example, and that's found in section 247. So we drew on existing concepts in the Act to look at what the test should be for both that supported bargaining stream and the single interest employer stream. So while the exact way that it is formulated is new, it's drawing on existing concepts.
And how would you put those into parameters for businesses to understand how it'll be interpreted, or are there these threads and then the interpretation and the precedent will fall to the Fair Work Commission?
It's fair to say that the way the test has been formulated gives a broad discretion to the Fair Work Commission. I draw parallels to concepts that businesses are familiar with, where there are high-level principles given in an Act, and then how that applies in granular or particular circumstances works out over time. So one of the best-known provisions in our law is the prohibition on misleading and deceptive conduct, for example. I can't quite recall the exact formulation, but it's something like, in trade or commerce, a person must not engage in conduct which is misleading or deceptive or likely to mislead or deceive. That was the old Section 52 of the Trade Practices Act 1974, and it's currently in Section 18 of Schedule 2 to the Competition and Consumer Act. It's a very high-level, principles-based section that has generated a huge amount of court litigation. You can find cases on how that applies in real estate, how that applies to future predictions. Businesses are quite familiar with needing to comply with that obligation because it applies to nearly every business. Similarly, the way that we have framed the common interest test, it's high level and principles based. We've tried to give guidance both in the legislation with the examples listed, but also in the explanatory memorandum of the sorts of factors that the Fair Work Commission will apply in determining whether businesses have common interests. But it is fair to say that there is a broad discretion that will be given to the Fair Work Commission to determine how that applies in particular circumstances. And part of the reason for that is to try and simplify the legislation to a degree. For example, if you look at the existing low-paid bargaining stream, that is an incredibly detailed and prescriptive part of the element of the Fair Work Act. It's also what we would regard as almost a complete failure. We've had 4 applications under that part, 1 was combined, and out of those 3 applications that remained, only 1 resulted in authorisation, and no enterprise agreements have resulted. The fact that we put very detailed and prescriptive elements in the legislation that was, I imagine, to try and give certainty to participants as to how it will apply, has actually resulted in that those provisions being inutile. We've tried to strike a slightly different balance in these provisions to give more discretion to the Fair Work Commission, but to be very clear about the principles that we're looking for. We're not looking for businesses with nothing in common, that they would have common interests. We're also not looking for businesses with just one element in common to have a common interest. We're trying to give guidance as to how the Fair Work Commission would apply that. And like the principles of misleading and deceptive conduct, that you would then sort of think about, well, what is the overarching aim of this stream? The aim of this stream is to allow employers and employees with enough commonality that they would be able to run an effective bargaining process to bargain together for the benefit of those employees, but also for the benefit of the employers, that they may not have the resources, for example, to engage in their own bargaining process, but as Ms Anderson and Ms Sheehan have said earlier, they may be able to pool their resources to bargain together, as we've seen successfully, for example, with Catholic schools, with Victorian hospitals, I think also with some Lutheran schools, for example, that they have this degree of commonality that they actually meet the higher tests in section 247 for a declaration, and they are then able to essentially pool their resources. They would typically appoint 1 bargaining representative and then work through the existing process of the Act to come up with 1 enterprise agreement that applies across multiple organisations.
Thank you, Ms Gordon. That's seriously impressive knowledge. And just sort of thinking this through, it's you're aiming for simple, which then broadens it right out, which then relies on the Fair Work Commission. So just thinking in terms of how long it's going to take to have some precedent and have some clarity for businesses, have you thought through how long you think that process will take?
Might help if I give you a practical example, a lived experience.
Well, I'm sorry, I'm more interested in how long. Yeah, there's a high degree of anxiety amongst small and medium-sized businesses around this. How long do you think that uncertainty would last for until they can say, okay, this is what common interest means?
To reverse at the start of my evidence, the 2 arms of the organisation, I'm responsible for the administrative side of it. That question goes to the tribunal and the composition of a full bench, which will be constituted to deal with that specific issue. But we're obviously aware of it. And just very quickly, Senator, the repeal of the 4-yearly Review and Other Measures Act provided the Fair Work Commission with additional discretion to overlook minor procedural technical errors in enterprise agreements. In terms of that, the Amending Act received royal assent on the 18th of December 2018. We'd issued a statement on the 11th of December which identified a range of issues that might be raised in the construction of the new provisions. We invited submissions, including from peak councils and any other interested party. A hearing took place on the 21st of December, so 3 days after the bill received royal assent. And then the full bench issued a decision on the 19th of January, so essentially a month later, Christmas sort of New Year's period as well, which set out a number of propositions in relation to the proper construction of the section, it's 188.2. That guidance from that full bench, I think, was constituted by and presided over by the President.
Okay.
Is still relied on by to guide members of the tribunal.
Okay, thank you. And just one final one. Something that keeps cropping up is this argument around roping in businesses, and I'm really keen to hear from the department. If I can just a quick scenario: if there's a single interest multi-enterprise agreement in place, already authorised in operation for a group of local childcare centres, who are in large part the focus of these reforms, if staff at another centre above the small business threshold would like to join that agreement, do they require the consent of the centre owner or operator to join?
There are two pathways, Senator, that they could use to join. The first would rely on consent with the employer, and the employer and the employees may make a consent application to the Fair Work Commission to be joined to the agreement. The second pathway requires an application by an employee organisation, so essentially a representative of those staff. And then there's a slightly different test that would apply for the Fair Work Commission to determine whether that centre should be joined to that existing enterprise agreement.
So it's sort of full consent, or a union can just say we want this group of workers.
If the union seeks to join the employer, like I said, there's a slightly different test that applies. So the employer has to be not a small business employer, as you've mentioned, but also the majority of the affected employees have to want to be covered by the bargain. The Fair Work Commission may work out whether a majority of employees want to be covered using any method the Fair Work Commission considers appropriate. At this point in time, that's most commonly done, I understand, through a vote of the employees, but it could be done by another method if the Fair Work Commission considered that to be appropriate. And then if the application is made by the employee organisation, everybody has to have an opportunity to express their views, and the requirements of the original test essentially have to be met. So either they have to be franchisees or they have to have a common interest. So while I can't really deal in hypotheticals, the Commission would take into account essentially the same matters that it would have on the original authorisation in determining whether to join that employer. So it would have a look at the nature of the business, the terms and conditions that the employees were engaged in, the geographical, whether they were operating under a common regulatory regime, for example, in determining whether it was appropriate to join that employer into that existing enterprise agreement, the same way it would if the application had been made at that earlier stage of the process when the authorisation was being determined.
Can I just ask about that authorisation then? My reading of the bill as it stands, that if you want to put an agreement to a vote, you need the unions involved to approve. If you have multiple unions and one of them objects, that then holds up the whole process, even if there's another union saying this is good to go?
So you're correct that each employee organisation needs to consent. So the employer has to request. So it's initiated by the employer. The employer requests the consent of all the relevant employee organisations for the agreement to be put to a vote. The requirement is for each of those employee organisations to consent. Part of that was to ensure that the agreement is genuinely beneficial to all of the employees covered by the agreement. So the employer couldn't wedge the employee organisations, for example, by giving a really good deal to some of the employees but not the others. And part of that is that stewardship role, because employers could be joined subsequently to that agreement. There's that role for the employee organisations to determine, is this essentially appropriate as potentially a framework agreement that other employers and employees could be joined to?
And this is one of the things that I really am sort of struggling to get my head around, because at every turn we hear how the Fair Work Commission is going to make all these decisions, an expert panel, they've got years of experience in this, they know what a good agreement does or doesn't look like. If that's the case, why are we allowing multiple unions to approve agreements if it's then going to the Fair Work Commission, who should be able to read through and go, this agreement stinks, like this is not good, or this is great?
It would be possible to frame an enterprise agreement that passed the Better Off Overall test, that for one cohort of employees, for example, it was significantly better off overall, and for one cohort of employees it was only marginally better off overall. The requirement for all employees to consent is essentially to try and safeguard against an employer, like I said, trying to wedge if you had a requirement that only one employee organisation needed to consent, giving a small group of employees an exceptionally good deal and then only a fractionally better deal to the rest of the employees. Now, I don't know, I can't tell you that that would result if all employee organisations weren't required to consent, but this is one of the safeguards that we've put in place in the bill to try and protect employees, having regard to those imbalances in bargaining power that we have been talking about earlier today.
Okay, thank you. And then just finally, on putting it to a vote, do casuals get to vote? How does that work?
So we haven't amended the current provisions in determining who is eligible to vote. There is some Fair Work Commission guidance as to when casuals are eligible to vote. Broadly, it usually picks up casuals who have worked in what's known as the access period before the vote.
Okay. And who would work that out in the process? In each workplace?
Usually that is something that both the employer and the relevant employee organisations would need to be satisfied that it's been done correctly. Otherwise, you could potentially have appeals being brought to the Fair Work Commission that an incorrect cohort of employees was eligible to vote.
Okay. So there's a fair few steps to get it to a vote, that's what I'm hearing.
They're largely in the realm of safeguards because of the importance of the employee vote in getting the enterprise agreement approved, that there are safeguards to try and guard against unrepresentative cohorts of employees, but also to try and take into account the many and varied employment patterns that people are engaged in. We've heard about fixed-term contracts before. In some businesses, there are also significant cohorts of casual employees, and a lot of this jurisprudence has built up to try and address, with the changing nature of our workforce, how do you get a fair and representative cohort that votes up an enterprise agreement?
We also have tried to remove some of the complexity around those pre-approval steps. So have taken out some, the Act at the moment has very detailed, certain things to happen within 7 days or 21 days, and have largely removed those prescriptive requirements and replaced it with the Commission issuing a statement of best practice on what's required for genuine agreement. So still give guidance to the parties as to what's expected to occur, but just to try to remove some of that.
There's still requirements for all employees to understand the agreement.
Certainly that would still be expected to be part of it, and I should say that more of these requirements have been lifted for the multi-enterprise agreements because employees, at least some of the employees, have to be represented in these multi-employer streams. So you do know that there is at least one employee organisation in the mix who is able to assist employees and to guide them. The detailed pre-approval requirements that Machine is referring to, that we are looking at this broader concept of genuine agreement now in the bill in Part 14, is an attempt to try and really hone in on what is the key issue here, what is at stake. Employees must genuinely agree to what they are voting. That means they need to understand it, they've had an opportunity to get across it, and as Machine noted, the legislation asks the Fair Work Commission to publish this statement of principles so that there is some guidance for employers to assist them in navigating from this set of really detailed pre-approval steps to a broader concept, to assist them through that process, and also to try and be a supplement without putting that level of detail in the legislation, to provide that there is somewhere that level of detail can exist and be provided to assist people to navigate the requirements.
Okay, thank you. Thanks, Chair.
Good, thanks. Senator Barbara Pocock has a brief follow-up question.
Just a follow-up from something Senator Pocock raised around the Fair Work Commission resourcing. The two specialist panels that are proposed, equal remuneration, pay equity and community and care sectors, what's your plan for commissioners in relation to those specialist panels, in terms of recruiting specialist knowledge to the bench or to the group of commissioners, and are you anticipating part-time commissioners that can draw on existing expertise? It's a small population of experts in this area. Just wondering what you're planning to do.
We receive funding for full-time members for the four members who were provided for in that funding measure. In what they may do, what they may focus on early in the reforms, is a matter for that expert panel, or those expert panels that are constituted at the time. I can't provide any information on the areas of gender pay, equity sort of issues that they may decide to focus on. They may seek submissions. There might be an annual work program. There are things of this nature. But in essence, my role is to support them, provide administrative support and research capability from an administrative perspective, from employees, public servants, and through contracting or consulting in some research capability.
So you don't see embedded or implicit in this Act that commissioners will need expertise to staff these panels? I feel there is, but I may be misreading.
Sorry, it is envisaged in the reforms, and I can pass it down the other end of the table if you'd like to talk to the specific detail about the background, skills and experience of the members who are to be appointed. As you'd be aware, Senator, appointments to the Commission are a matter for government.
Senator Sharon Hundar, acting as First Assistant Secretary, Employment Condition Division, there will be requirements around the expert panel members in particular. So for the two new expert panels, the bill amends the Fair Work Act to specify that the pay equity expert panel must have knowledge or experience in gender equity or anti-discrimination. And for the care and community sector expert panel, there must be knowledge or experience in the care and community sector. As Mr Furlong said, we did fund for 4 additional members of the Fair Work Commission. They can be part-time or full-time.
Okay, thank you. Thanks for clarifying that. Thanks, Chair.
Good, thank you. Senator Hanson.
Thank you very much. I just want to ask a general question. How many of you run your own business or employed staff, apart from being in public service? Sorry?
I'm a full-time public servant, Senator.
Full-time public servant. So no one's run a business, no one's employed staff. Okay, good. I think it's commendable that we're looking at increasing wages for working Australians. But I also want to hear from the other side. What investigations have you done into businesses? Can they afford it? What meetings have you had with which businesses, big businesses, small business, who have you met with to actually ask them, can they afford this?
I'll ask the department to assist you with that question, Senator.
Sorry?
I'll ask the department to assist you with that question, Senator.
Okay, all the businesses that you have actually spoken to with regards to this, can they afford it?
So, Senator, as we have outlined in previous evidence, we have consulted with a broad range of stakeholders in the development of the bill. I think we've had over 50 consultations. I think most of those have occurred with employer associations, including small business employer associations. As I noted earlier as well, in terms of what the bill intends to do, it does do a range of things, and interaction with the bill will vary amongst workplaces. As we said before, the important thing to note is in relation to some of the concerns around the single interest stream, small business are specifically exempt from that single interest. So I think I'll go back to the hairdresser analogy.
Okay,
they would largely
you say
be
small
exempt
business,
from the
small
single
business
interest
up to
stream,
how many
for
employees?
example.
What are we talking about? How many employees?
Sorry.
You said small businesses are exempt.
15 or under.
Okay, 15 or under. You stipulated here, the question came about casuals. It's not really stipulated, casuals, or how many hours they work, is it? So if they're an employee of the business, you're not stipulating how many hours. So if someone who's a casual works for 2 hours, they can be then involved in the bargaining.
So are you asking about how casuals
Well,
are
I'm
considered
saying,
for calculation
okay,
towards
you're
the
talking about
15?
small business of 15 or less, not involved in this as well. But you're not saying those employees, how many hours do they work in that business? So you might have 15 or 20 employees, but those 15 or 20 employees, some may be on full-time, others may only work about 2, or 3 is the limit, might work only 5 hours a week. So therefore, they're going to have a say in the enterprise bargaining agreements of full-time employees. Is that correct?
Senator, for the purposes of calculating whether an employer is a small business employer, we've used the definition in section 23 of the Act, which provides that all employees are to be counted, except casual employees are not to be counted unless at the time the employee is a regular casual employee of the employer. So if they are a casual who works maybe 2 hours here, 4 hours there, then another week maybe picks up 3 days worth of shifts, then that would be difficult to say that they were a regular casual employee. So it's really designed at trying to get to that 15 head count is to try and pick up those employees who are regularly working at the business who have that.
That's in the bill?
State.
You've stipulated
that's currently in the
it's
Act, so that's section 23.
And that will flow onto the bill. So
and that definition has been used in the single interest employer authorisation, which is in part 21 of the bill.
Right. Just tell me, are there any industries, businesses that's exempt from this rather than the numbers? Is there any industry that's not going to be roped into this?
So there is an exclusion in Part 23, capital A of the bill. It's an exclusion that looks at an employee undertaking excluded work, which is general building and construction work. It's defined by reference to the relevant award, Senator. So if you're covered by paragraph 44.3, subparagraph A of the building and construction general.
So you're saying the building and construction industry?
The general building and construction industry, not counting civil construction or metal and engineering construction.
I've got a note here from the Master Builders Association, and correct me if I'm wrong because I'm going on what they've advised me here. Whilst the bill does contain exclusions in respect of general building and construction work, the bill does not exclude employers in other parts of the industry, such as civil, construction or metal and engineering construction from multi-employer bargaining. These subsectors of the construction industry are critical to the economy and therefore the MBA's concerns are legitimate and relevant.
Senator, it is correct that work in the industry of civil construction and work in the industry of metal and engineering construction are not excluded from the multi-employer bargaining. So it is not excluded work within the meaning of Part 23, capital A.
So unless you stipulate the business is not included, because I'll go back to your own words, identifiable common interest. So if you're in the construction industry, you're in the construction industry. So you can be roped into this.
You are excluded if you're working in that general building and construction industry, so you couldn't be found to have a common interest if you're in that because you're just excluded entirely, the same way as a small business with less than 15 employees is excluded entirely. You don't get to that stage of the test.
So just clarify with me again, what part of the construction industry is not involved in the MBAs?
It's if you are in the industry of general building and construction within the meaning of paragraph 4.3A of the Building and Construction General On-Site Award 2020.
So I might just add that doesn't necessarily mean that everybody that's left over necessarily has a common interest. They would still need to, that would still be a factor that's considered.
If you want to, because, this is your area, you've been of this law.
So you've got a mixture of within the workforce.
Those employees that would be covered by general building and construction would be out.
So half the workforce could be roped in, let's say it's a 50-50 split and half out.
So, Senator, I think we just have to keep referring to the evidence that we've already provided about this concept of being, roped into single enterprise agreements. There are a range of, there is a clear test that is included in the bill in terms of whether you can actually even engage in this in the single interest stream. So a lot of the sectors that you're talking about in the construction sector already also have enterprise agreements in place. So if they have existing enterprise agreements in place, they continue to operate. They cannot be roped into the single interest stream. Also, if they are in the process of...
Until their enterprise to bargaining agreement expires. Then after it expires, then they can be roped into it. Isn't that true? Because
Sorry, Senator. So if they've agreed to bargain for a new agreement, then they can't be brought into the single interest stream, and then the Commission also has a discretion to look at if there hasn't been agreement to bargain. The Commission can look at has there been a history of effective bargaining in the past, and looking in particular at the last 6 months. So it's not just if the agreement expires that you're then automatically brought in.
An employer has a single enterprise agreement that expires, exposing it to multi-employer bargaining after 6 months. After the single enterprise agreement passes its normal expiry date, the union and employer commence negotiations on a new agreement. The union demands terms that reduce the productivity and viability of the business. That's example, rostering arrangements that would be unworkable, or family and friends provisions, as has been seen in the maritime industry. After 6 months from the date of expiry, the employer is exposed to being roped into a multi-employer agreement. If the union threatens to do so and the employer agrees to unproductive and restrictive terms, locking in low productivity. So basically, you're actually going to say that if their enterprise bargaining agreement finalises, then if the union step in and say, well, look, you're going to roped in now, you're going to have an enterprise bargaining agreement. So what does the employer do about this? There's no control over it, is it?
If the employer and the employee organisation, it just takes one of them, have agreed to bargain, and that's in writing, there is no time limit. That just operates as an exemption from the ability to be added to a single interest employer authorisation in its many and varied forms. So the 6 month limit is the additional discretion on the Fair Work Commission where there is no agreement to bargain, but the employers have been bargaining in good faith, and there is that history of effective bargaining. So it's essentially an additional safeguard, but if there's an agreement in writing between the employer and the employee organisation, there's no time limit on that bargaining.
You know, unions can walk into these workplaces, you can't stop them. They can sit down, they say, get them all together. And the union puts to the workers, do you want a pay rise? Of course everyone is going to say, I want a pay rise. Well, listen, we're going to go with this. We're going to go for a enterprise bargaining, and therefore the employer has to accept it. Otherwise, you've got problems, and the unions will take industrial action and shut down the business if they don't agree to it. Is that correct?
Senator, there are a number of parts to that question. The first is that there are specific right of entry rules that determine when a union and its representatives can enter into a work site and have those discussions with employees. Then you get to the many and detailed steps that have to be gone through in order for the employer to essentially commence multi-enterprise bargaining against its will. So the employer can always volunteer through the cooperative workplaces stream or volunteer itself into the single interest stream. However, subject to some safeguards, but where you're talking about an employer being required to engage in multi-enterprise bargaining without its consent, we're either talking about the single interest stream or the supported bargaining stream, and there are safeguards in terms of decisions that the Fair Work Commission must make in order for...
Okay, so the safeguard positions. If the employer comes to you and says, look, these are unreasonable, I can't afford this, it will shut down my business, it will actually destroy and I will actually have to lay off people or I'll have to move overseas. What do they do then?
So that would be relevant...
Listen, I'd like to hear from the Chair. I'd like to hear from the General Manager. Please?
Senator, as I traversed at the beginning of this hearing, My role at the Fair Work Commission is largely responsible for the administrative arm. Any questions that go to policy and the...
But you should have an overall view of this. You must know what's going on.
Senator Hanson, sorry, I very much tried not to intervene in anyone's line of questioning. Mr. Furlong gave us an outline
I find
before.
it very difficult. So, I'm sorry.
Mr. Furlong
I'm
gave
not
us...
100%, but I find it difficult to understand you with the mask on. Thank you very much. I appreciate your health concerns, but I find it very difficult. My ears aren't working properly today to actually hear you clearly. But thank you I do appreciate that. Okay.
Senator, could I just
Can I,
add-
because I just want to say, I don't get an argument about this, but as long as the person is comfortable taking the mask off, that is part of the conditions of if people want to keep masks on or off. So that's, I just want to make sure you understand that the chair is comfortable whatever you decide. But Ms. Sheen, if you could answer the questions, I think that will help Senator Hanson.
Yeah, I also appreciate we're running
Whether Senator Hanson agrees with your comments is up to her, obviously. But
Of course. I just thought I'd add the scenario that it sounded like you were describing was maybe where, bargaining wasn't going well and the parties weren't able to agree. I thought it might help to highlight that one thing that this bill does introduce is a new way to access arbitration for intractable bargaining disputes. So if the parties have been bargaining, they're not getting anywhere, there's no reasonable prospect of agreement being reached, then a party could apply for arbitration, which at the moment under the Act, it's an incredibly high threshold as to when you can get an arbitrated outcome. Essentially, you have to have protected industrial action's been taken, it's of been such a nature that it's then been terminated by the Fair Work Commission and then can get to an arbitrated outcome. So the idea is to still have something that's a fairly high threshold, but the Commission would be looking at, have the parties tried to resolve their dispute by using conciliation processes under the existing provisions? Is there really no reasonable prospect of agreement, and is it reasonable in the circumstances for the Commission to grant that declaration? But there is that avenue as well if bargaining just isn't getting anywhere and the parties aren't able to resolve their disputes.
You couldn't tell me how many meetings you had with large businesses and that type of thing, or note them. You're going to get that back to me, which is good. How many meetings did you have with unions, and name the unions and which unions, please?
So, Senator, bear with me. I'll just get my...
We'll just find the figures for you.
So, Senator, in terms of you're asking specifically about which unions?
Yeah, which unions and how many meetings?
Yeah. So we primarily met through the ACTU, which represents its affiliates, and we met with the ACTU around 7 times. We also conducted what's called a committee on industrial legislation to consult on the actual drafting of the bill itself. And at that meeting, there was the AMWU, the Transport Workers Union, the Australian Workers Union, the Australian Services Union, the United Workers Union, Health Services Union, the Community and Public Sector Union, the CFMEU, the Australian Nurses and Midwifery Federation, Professionals Australia and SDA.
They've really had a big input into this, considering that only 14% of Australians are in unions.
So in terms of the so we conducted over 50 consultations. So as I said, around 7 of those with unions. The rest of the consultations were with employer associations, so Australian Chamber of Commerce and Industry, AI Group, Minerals Council, Business Council of Australia, Housing Industry Association, COSBOA, Australian Retailers Association, HIA, they were the main ones that consulted.
Well, I'd like to, the Minerals Council of Australia, and I've spoken to them. they can't understand why they're getting roped into this, because actually the mines have very good enterprise bargaining agreements with their workers and pay them very well. Why are they roped into this?
That's probably the point that you've just made. Probably answers the question. They already negotiate. They already have EAs in place. So the concept that they'll be roped in.
Clear there, Chair, not in Western Australia. That there is a fundamental difference, just for the Hansard record.
Well, that's right. So when you talk about these enterprise agreements are basically identifiable and common interest, and also in the, I'm just trying to think, in where they're positioned, okay, where they are. So you can't make a difference between the East Coast, a mining company in the East Coast, to that on the West Coast. So if you have an enterprise bargaining agreement, it could actually impact those in the West Coast. Is that right? All right?
Senator Hanson, last question, if that's okay. If you have a follow-up, I'll give you time for a follow-up and then I'll go to...
Right. I just want to ask you another thing, okay? Well, I haven't got time to ask that question. You talk about the enterprise bargaining agreement. Now, have you actually looked at the public servants' enterprise bargaining agreements?
I'm broadly aware of the arrangements in the public service.
You're getting involved in the public sector. Can you tell me then what a public servant on an E4 or E5 gets paid? We won't go into what money they get paid. In the public service, a person on an E4, E5 pay in the public service can be on a different pay packet depending on what department they work in. So if you work in the defence, you get paid more on an E4, E5 than what you do in someone in another department. So what amazes me is that you haven't cleaned up your own act in the government departments with EBA agreements and people on the same pay packet with enterprise bargaining agreements, yet you're interfering in the private sector where businesses have to, be able to tread water and pay their bills, and yet you haven't dealt with it in your own backyard.
Senator, we'd have to refer general questions about Australian Public Service enterprise bargaining to the Australian Public Service Commission that has overarching responsibility for that. But as a broad matter, although I'm not aware of the E4, E5 classification as a broad matter,
Well, it's been brought
different
to my attention.
different
Apparently
Commonwealth.
It depends on what department you get paid in. You might be in a higher pay wage than the other. So if you're really looking after people's wages, clean up your own backyard first before you start interfering in private business out there that's trying to survive after going through COVID and the downcline in the economy.
Thank you, Senator. Senator David Pocock has a quick follow-up question.
Thank you, Chair. I just had a follow-up on the union veto clause that we were talking about earlier, and you've seen in the news people like Minister Shorten, Sally McManus talking about workers desperately needing a pay increase by Christmas, which I agree with. So many Australians deserve and need that. Clearly, this bill is very unlikely to deliver that in that time frame. But in terms of the time frame, do you see having multiple unions having to agree before something's put to a vote as potentially slowing down how quickly this bill could get wages moving?
I would say, Senator, that this is one of the safeguards, as I previously referred to, and it is a balancing act. As Machine has referred to previously, we've also undertaken a balancing act with the approval requirements. So across the bill, there are a number of measures that we expect would make it faster for enterprise agreements to be approved, and there are some safeguards that have been put in place which will have to be gone through in order for an enterprise bargain to be approved. It's a balancing act. Overall, I couldn't tell you whether it is going to be faster or slower, but I would say that compared to the current provisions, we have removed some of the steps for single interest approvals, and we have also significantly streamlined the requirements for the supported bargaining authorisations. So we would expect that, on balance, it's a fair weighing of concerns in terms of those steps that we've removed and the safeguards that have been put in place, and that will pull in both directions.
Thank you.
I was going to say, you'd also hope that
by requiring employee organisations to agree before an agreement's put out to vote, that you might have better quality bargaining and therefore a better quality agreement that then assists the Commission when they're considering.
But it seems that would potentially take more time.
I mean, it's not designed to be to add more time to the process, but it's difficult to put an exact time frame on these things. Each bargaining period is different for I guess each agreement, but it is designed to ensure that proper genuine bargaining has occurred, and it's agreement that is going to benefit the employees before it's then put to vote and then to the Commission for approval.
Okay.
Senator, if we could refer you to our question on notice, I think it was 00036356, and that provides probably a bit more detail to the question that you've asked.
Great. Thank you. You're sounding like crossbenchers wanting safeguards and due process. It's good to hear.
Senator Grogan.
Thank you, Chair. There's been a lot of concern raised regarding the impact that this bill may have on small business, and I wonder if you could just clarify a few points for us. Back at the first hearing of this inquiry, ACTU President Michelle O'Neill addressed this, saying, and I will quote, "We know that small business are largely unionised. They're not businesses that are traditionally involved in taking any industrial action. People work really closely together with their employer. They're often engaged daily just in trying to work out how to keep the business running and how to meet workers' needs for their families as well as their business needs." And she went on to say, nothing in this bill is going to change that. That's the reality. Even when unions had 60% density in Australia, there was not unionisation of small businesses, and there is no history of industrial action in relation to small business. It's a long way from where we are today, and this bill will not change that. So the fact that small businesses have not been unionised in the past, not when the density of unionisation was 60% and not now, do you see any provisions whatsoever in this bill that will change that?
The unionisation of small businesses? I know that the bill itself would not change that. In terms of, I think, impact on small business, generally small businesses at the moment could agree to bargain under single enterprise agreements, so that's something that remains the same. In terms of, as we've discussed, in terms of entry into the single interest stream, then there is an exemption from small businesses using the current definition in the Act from entry into that stream. In terms of impact of industrial action, the bill actually introduces additional steps before industrial action could be taken. For example, longer notice periods for a industrial action in a multi-employer stream, and also conciliation that would need to occur first. So I think
Just to note also, we mentioned earlier as well, just the point that the Fair Work Commission will also be getting that 7.9 million over the forward estimates to give that additional support to small business where they wish to get engaged. So that obviously provides an avenue to work directly with the Fair Work Commission to get the benefits of bargaining.
Senator Cash.
Thank you. And just some follow-up questions, if I could just return briefly to page 51 of the regulatory impact statement in relation to the costings for the professional service fee. For this costing, we've used an estimate that 2 employers will lead the negotiations for a multi-enterprise agreement and factored in a professional service fee of $175 per hour. Then you've got a number of scenarios, $175 times the 4.6 hours times 31 days of bargaining for a small business times 2. I would put 2, it'll be a lot more than 2, $49,910. It then goes through medium, $273,700, and large, $322,000. The footnote is 70, which, as I referred to you previously, How much should I charge as a consultant in Australia? Authentic.com, and you've come up with this service fee of $175. Can I ask, in terms of the author of this particular website, I just want to read out to you what's on the website in terms of his biography, and then just get your guidance in terms of what actual industrial relations and bargaining expertise he has. It says on his website, a cross between business strategist, modern-day spiritual healer and self-development expert, Benjamin J. Harvey is as comfortable with working with shamans to strategists, psychics to sales reps, healers to homemakers, Buddhists to businessmen, and meditators to mediators. Again, can I just ask the department, what industrial relations and bargaining expertise does Benjamin Harvey have?
Senator, the point of the costing there is that it replicates, I suppose, a cost of a consultant generally. I will just make the point, though, in relation to small businesses, again, they are exempt from the single interest stream.
Again, so you think that a cross between business strategist, modern-day spiritual healer, self-development expert, comfortable working with shamans to strategists, psychics to sales reps, healers to homemakers, Buddhists to businessmen, and meditators to mediators is sufficient to actually get you to $175 per hour. Anyone can Google this website. I should actually suggest you do, to actually see how they get to $175. Which in this category of persons that he is comfortable working with have expertise in the Fair Work Act?
Senator, I'll just repeat my previous evidence that the 175 represents an average consultancy figure.
Based on this particular biography. That's fine. Correct. Can I just go back to the issue with small business? See, this would be, as Senator Hanson well knows, as someone who for many, many, many years ran a small business, would appear to be where a lot of the confusion lies, because anyone who runs a small business knows that a 15 headcount or less is quite frankly irrelevant. You've also said, though, in terms of Senator Grogan's question, the bill would not actually change the impact on the situation for small businesses in this country. My understanding is, though, that in terms of businesses, say, between 19 to 199, there are around 86,000 in this country. I personally would argue many are small businesses. My understanding is, though, they can be compelled into bargaining. So how doesn't it change the situation for them? Unless you're telling me I've completely misunderstood this entire bill and they cannot be compelled into bargaining.
Senator, my answer before the beginning of that was relating to whether the bill would change the unionisation of small businesses, and then.
So you know that, do you? Because this starts to get very interesting. How do you know that?
In terms of the provisions of the bill.
Well, how do you know that? What small businesses have you spoken to?
Can we allow Ms. Jean to answer? I'm also mindful there's 2 minutes left, but I will give you a follow-up question though.
So the point that I was making is that there's not provisions of the bill that would require employees of a small business to be part of a union, and then the rest of my answer was outlining how small businesses now can bargain in the streams. And then how that would change under the bill and the exemptions in place for small businesses using that current definition in the
So what do you then say, and we talked about this at estimates, to Mr John Setka's proposition, and I quote, that this bill allows them to go after non-union workforces? Is Mr Setka wrong?
Sorry, could you repeat the beginning of your question?
What do you say then, given your evidence, to Mr Setka's proposition, and I quote, and we discussed it at estimates, that this bill allows them to go after non-union work sites?
I would say that there's no provision in the bill that changes the rights of employees to either join or not join a union.
Good, thank you. Well, I'd like to thank you for your evidence today. If you've taken any questions on notice, could you please return the answers to the Secretariat as soon as possible, noting that the committee will table its report later today and the Senate will be considering the bill during the sitting fortnight. That concludes today's hearing. Thank you to Hansard and Broadcasting and to the Secretariat for their assistance. The committee stands adjourned.